All right. Thanks so much. I'm going to introduce our next panel. So we heard this morning and in that last panel, really what happens at bail, if someone's unfit, or they may or may not be found NCR. So we're going to shift now to the Ontario Review Board on the presumption someone has been found unfit or NCR. And I will introduce your panel. First, Anita is going to be moderator. And I think we all know and love Anita. No? More? So your panel members today include Leslie Maunder. Leslie currently sits as an alt chair on the Ontario Review Board, and she sits also as a senior legal member on the Consent and Capacity Board. Before those roles, she was a prominent defense counsel here in Toronto and often at the Court of Appeal, and then she was counsel at the Law Society. Dr. Pearce is also here. He's a staff forensic psychiatrist at Ontario Shores and at CAMH. Much of his bread and butter includes assessments for fitness, NCR, risk assessments, etc. AJ Grant-Nicholson is a defense lawyer with the breadth of experience in mental health law. He's done policy work at the Law Society, or not the Law Society, Legal Aid Ontario. He's also worked at the Mental Health Commission of Canada, and he also runs his own defense firm. Finally, last but definitely not least, is Michael Feindel, who is a guru in this field. He is an assistant Crown attorney, and he works as the ORB Crown coordinator for the Toronto region. So if you read any ORB law, his name is on many of the cases, and often in combo with Anita. So with that, I'll turn it over to Anita.
Introduction. So what I thought we'd do with this panel is we're going to sort of go around the room or down the aisle here, and each panelist is going to introduce sort of their role or what happens in their world. We'll start with Leslie, move to Mark, Michael, and AJ. So Leslie, could you, in 5 minutes or less, just tell everybody what the review board does and how it does it?
Sure. So if an accused is found unfit or not criminally responsible, they're referred to the board, referred to as the ORB here in Ontario. The board conducts hearings and makes decisions that have profound impacts on those who come before us. For those who are found NCR, if the board finds them not a significant threat to the safety of the public, they'll be granted an absolute discharge and they can walk away. No further involvement with the criminal or forensic system. On the other end of the spectrum, the board might find they are a significant threat, detain them at a high secure forensic hospital, i.e. Waypoint, where they have no access to the community at all. There are many, in fact, most of our decisions fall somewhere in between those extremes, some of which may surprise you. Many individuals are on conditional discharges where they report to the supervising hospital once a month, living in their own apartment, really for the purposes of ensuring they remain stable and they remain on their treatment, perhaps. There's other individuals who are detained in a hospital, but exercise privileges such that they're holding down full-time jobs while living in a hospital or going to school full-time. So it's important to know just the broad range that might happen under our jurisdiction. Legally, these decisions are governed by two questions. One is, does the evidence establish that the accused is a significant threat to the safety of the public? The threshold question. It's discussed at length in the jurisprudence. WINCO is 101, but in a nutshell, the risk has to be real, not trivial, not speculative, conduct that must be criminal in nature, and sort of a weighing of how likely the risk is to occur, along with how severe the harm would be if it did occur. Once that threshold is established, the next question is what's the necessary and appropriate disposition? or the least onerous and least restrictive. Not just whether to order a detention order or a conditional discharge, but the various conditions and privileges that go along with those orders that frame how much liberty the person has. The job is to capture the sweet spot where you're maximizing the person's liberty while protecting the public. How do we do it? Administrative hearings, they're quick and informal. They're scheduled for 90 minutes unless you ask for extra time. The panel will typically have 20 hearings in a week. It's a specialized panel of 5 members. There's 2 lawyers, a psychiatrist, another psychiatrist or psychologist, and a public member. All will have significant relevant experience, including the public members. By and large, they've had significant roles in the administration of forensic hospitals or as social workers working with the mental health community. You'd be surprised how much they know about what they're being tasked with. There's 3 parties: the hospital, the attorney general, and the accused. The hospital prepares the hospital report with an update on the progress of the patient over the year, but that also captures the history under the board and before, hearkening back to the previous panel. Very important not to let things that are incorrect or damaging that shouldn't be in that initial NCR assessment
Say that again.
just stay there, because it will follow that patient forever. The attending psychiatrist will testify and be cross-examined. Board has lots of questions. It's inquisitorial, not adversarial. Lots of hearsay goes in. Accused sometimes, but I would say not frequently, testifies. What the board is looking for in a nutshell is why and when is or was the accused dangerous, and how have those factors been addressed? Or have they been? Have they been addressed, and how? Just finally, keep in mind this entire exercise the board is undertaking is assessing risk in an effort to predict what's going to happen in the future. It's not an exact science. While the format of these hearings, particularly how quick they are, how little time you have, might create challenges for advocacy, it's actually an area where good and laser-focused advocacy can make a huge difference for your client.
Thank you very much, Leslie. That's a really succinct, very helpful overview of the review board's role. If you are not familiar with the review board's work, you can seek to attend their public hearings, and I think you'll find it a different world from your criminal courtroom in positive and other ways, but you should come and visit. Mark, can you tell us about your role as the hospital's witness or the attending psychiatrist, and how you take positions, how you present your evidence?
Yeah, thanks.
Or
Thanks
whatever
for
you
having
wanna
me.
say. Yeah.
I hope I'm using this properly.
Good job.
Yeah, so I'm a forensic psychiatrist. I work at the CAMH and at Ontario Shores. And most often my role at the hearings is to act as the attending psychiatrist witness, which means I'm the patient's attending physician at the hospital. They might be an inpatient or an outpatient. At Ontario Shores, they promoted me to representing the hospital. So there's no hospital counsel there at Ontario Shores. They didn't give me any extra pay for that, but I still do that there. And at CAMH, they don't let me do that. So maybe that tells you about my reputation at the different hospitals. I'm not sure. So anyways, yeah, 95% of the time I'm the attending psychiatrist. Sometimes I've done a risk assessment, an ORB ordered risk assessment. And in those cases, I may have a bit more detached role from the process than as the attending and treating doctor, right? So it's a bit of a dual role with the ORB, and then I have to be their attending psychiatrist, and that my job is, as per my role as a physician, to advocate for them and try to help them. And at the same time, I then have to go to this hearing once a year, wherein I may be asked all sorts of questions like, why are they so dangerous? Who are they going to, murder or harm next, right? So So that can be difficult.
the
It can
common
be a
question.
challenging role.
Comes up every hearing.
Comes up every hearing. Yeah,
Yeah.
that's right. So we also prepare the report, right? I work with a team, a multidisciplinary team at the hospitals. We work together to prepare the report, although usually I have to, I guess, bear the primary responsibility for it and the contents of it. But the person in charge of each hospital does review it and also sign off on it as well. And if they don't like what I've said or disagree with it, then we'll have usually a meeting before the report gets disseminated out. But sometimes there may be a difference of opinion between what the treatment team and me think as compared to what the person in charge thinks. And that's probably occurs maybe 1 out of every 20 hearings. So I attend about 60 to 70 ORBs per year because of my clinical caseload. So I know many people in this room. That's been the case since 2007. And I guess what I would add, beyond any questions or whatever Anita may say, and we'll see what she says. I hear she's on some medications now, so maybe she'll ask some interesting questions that she's been dying to ask for a long time. Is that, most of the hearings, it's usually a joint position. But even in that, if that's the case, sometimes I'm still asked to articulate, why the person is so dangerous. And that's a difficult role to play because I don't want to impair my working relationship with the patient. I want them to feel confident in talking to me and trusting me and opening up to me as much as possible, right? And so sometimes when I'm asked that question and it's a joint position, I think to myself, why the hell am I being asked that question? And I try to gloss over it, and then sometimes they try to pin me down, and if they pin me down, I'll have to answer, in a fulsome way. But that would be the toughest part, I would say, of the hearing, is trying to juggle that dual role. And it also, when I go to the ORB, well, I know the majority of the panel members most of the time. Sometimes I don't. And, there's no tendering of my CV. Like when I go to court, there's a voir dire about me becoming an expert witness and giving expert testimony in whatever area. But at the ORB, that's not the case, right? And so perhaps we'll hear from some of the other parties here about how they then know how to weigh the evidence, given that, they don't know anything about me or they haven't seen my CV or anything like that. So I always find that kind of interesting as well.
Mark is one of my favorite psychiatrists to do hearings with. Just give you a quick example of how he does it. I'll never forget. I always talk about this. I'll never forget. He gives his testimony at a hearing. He says, they ask him, update for the year. He says, oh yeah, my patients had a fantastic year. And we roll around to the panel members' questions, and the psychiatrist member says, well, you say he's had a great year. He says, yeah. A panel member says, wasn't he in hospital for 4 months out of the year because he had to have refeeding because he was starving himself because he was afraid of the poisoned food and that? And Mark says, yeah, but apart from that.
He hadn't hurt anyone, so that was my main.
Apart from that, it's been a banner year for the accused. Michael, what about the role of the Crown at review board hearings? Can you give us a sense of the?
A little bit, yeah. I thought it was
whatever you want. Give us a
my
sense of
advantage
something.
Sitting
Yeah.
at the end here. So the Crown, again, thank Anita and the organizers for this conference. I think it's been a really useful day to hear from everybody. I think I have one of the better jobs in the Ministry of the Attorney General, and that is my practice is exclusively devoted to this area of law. And there's a number of, I won't go into all the reasons why I enjoy this area of law, but it actually engages a lot of different aspects that you won't see necessarily in a criminal trial court. Its inquisitorial aspect is very interesting. You're dealing with a psychiatric discourse, which is that you have to become quite familiar with, which is quite interesting. And the cases take a direction which, quite frankly, is very different, in my opinion, from what happens in a trial court. And while there's absolutely a lot of negative things about that we've heard about today about some of the review board process, there's at least it has a forward look. I would argue has a forward-looking perspective, and I get to see results that none of my colleagues get to see when they're doing criminal trials. So that's one aspect of why I think this is important work. When I'm at the board, I'm not a prosecutor per se. The role, it's a different role, and it's defined under the statute where it's an odd status or standing that the AG has at review board hearings. We're not a essential party in the sense that a review board hearing could proceed without the participation of the Attorney General. But there is a provision a statutory provision which allows us to become parties. And if we seek that status, the board has to grant that status. So it's a kind of a mixed bag. So technically, I don't even have to be there for these hearings, but in our province, there's generally speaking a Crown always present, not in every other province in the country. And that's another aspect about this practice, just to do a little digression. It varies from province to province, which is quite unlike criminal law in the normal course. BC has a very different system. Quebec has a very different system. I think some of the questions have asked about Quebec today. Maybe we'll get into that in this panel. Just to move on quickly, though, one of the things I think the functions I serve is there's a few functions. One is to provide information, usually from the court system and the police system. So records from those sources, it's harder for other parties to access that, not so easy even for the board to access that. So the Crown often facilitates that information getting before the board. The other pieces, which I've heard no mention of today, is victims. And victims actually have a very different relationship to the criminal justice process under the review board system as compared to the trial court system. Victims technically are sort of a standalone component. The board reaches out to victims to advise them of their rights. The board reaches out to victims to invite them to submit victim impact statements. It's not the Crown. So the victim is not, quote, my witness per se. It's actually a participant that the statute allows or actually encourages the board to facilitate their participation. So that piece, working with victims, but practically speaking, the Crown ends up doing a lot to sort of assist victims, explain to them what is a very unusual process to them. They often don't understand how it all works and are often in a state of a lot of upset or frustration at how the case has gone because it's taken this direction that is to them very unfamiliar, doesn't seem like justice in their eyes. So that's actually quite a demanding piece of the work that I do when I'm at the board hearings. And maybe lastly, do I have a couple minutes? The last thing I wanted to point out, often, and it has been put to me and other Crowns, what is the role of the Crown, though, at a review board hearing? What's our angle, as it were? And some have suggested, well, shouldn't you just be there to be a zealous advocate for public safety? And for sure, that is definitely one of my roles. But as you've heard many times today, Part 20.1 has twin goals to its structure. So there's the least onerous and least restrictive disposition in terms of impinging on the accused's liberty as minimally as possible, and public safety. And so it's a bit of a red herring to me when asked, well, shouldn't you just be arguing public safety? If you start arguing, the balancing of the two twin goals, what's the difference between you and the review board? Well, I can't necessarily always demarcate that difference, but we're all dealing with one section, section 672.54. That's the governing section. And if I'm a litigator and I want to convince people of what I'm saying has merit, I'm going to speak to that section. I'm not going to speak to a part of it. I'm going to speak to the application of the whole twin goal approach. So when I come to it, I am looking at least onerous and least restrictive as well. To me, it's as much as part of the formula as public safety. Maybe the Crown brings a little more finesse to the issue of public safety. I don't know, but that's something I'll leave for others to comment on. But that's all I have to say.
We're very lucky to have Michael in Toronto as our Crown. There's nothing better than a Crown at these hearings who's independent minded and doesn't just follow what the hospital suggests. It always comes as a shock to the review board. Close your ears, Leslie, when that happens. One of my favorite things that happened in this last year was one of our local hospitals wanted to ship my client up to Waypoint to maximum security. And of course, we were opposed to that. We had a pre-hearing conference about it, and it was, ticking along. Yeah, defense opposes, blah, blah, blah. And Mr. Feindel, blah, blah. And then, Michael said, well, the Crown opposes also the more secure disposition. All of a sudden, well, that's a completely different ballgame. There must be some problem with the recommendation. But it's so nice when they're on your side. But perhaps I digress. On the issue of victims, we can have an entire conference about the disservice we do to victims by pretending like they can have a meaningful contribution and voice at the review board hearings, because ultimately very little, if anything, that they are allowed to say within the confines of the law goes directly to the decision-making by the tribunal. And so I feel terrible for victims in this process, but maybe we have another full day on that. But now we turn to AJ. As defense counsel, isn't it wonderful?
It's the best. Best role.
It's wonderful. It's highly paid. It's lucrative. The tribunal respects you. Everybody loves you. The families are excited when you come and get everybody out. It's a joy. Would you agree?
Yes, completely. It's a weighty role, but it's very rewarding. As Michael said, it's different than other types of work I do in my practice. It's not as transactional. There's an opportunity to see gradual progression towards a goal, and that's quite often how it plays out. I would say my role is to be an advocate for the accused person, to take their instruction. I think working with this population, persons with psychiatric illness or mental health conditions, it's easy to become paternalistic and to do things that you think are in their best interest. However, I think it's best that, professionally speaking, you should be getting instructions from your clients and meeting with them as soon as possible. I mean, as soon as I'm retained, I try to meet with my client in person to get instructions. I try to meet with them so I get a better sense of what they want, what their goals are at their ORB hearing, get a sense of who they are. I think it's very important to establish rapport. And once I do that, I can then start, with their permission, start looking at their clinical record. So, I have to do a deep dive in the clinical record. When I first started doing this work, I reached out to a friend who was a psychiatrist, and I had to get a crash course in terms of reading a medical chart. So it's very important if you're doing this type of work to get some background in terms of understanding clinical types of language, psychiatric pharmacology. It's very important to understand the basics and just how a chart is set up in shorthand. So you're going to have to do a very deep review. You're going to be looking for, positive information about your client, perhaps periods of time when they're really doing well, things that can support, a position they want to take at the board in terms of trying to maximize their liberties, or maybe even trying to seek an absolute discharge. Then, you're going to eventually get the health report. Sometimes you get it a little bit late. Hopefully you get it sooner than later, but you review the health report. The health report will include information about the index offense, so you're going to want to go over that. It's going to include actuary assessments. I think the last panel did a great job of talking about those kinds of assessments and perhaps some of their limitations. You have to think about ways of challenging it. I think it's important as lawyers that we familiarize ourselves with these types of assessments, recognize that we're not mathematicians. We don't have expertise in that kind of field. So when necessary, you have to seek out that kind of expertise to better understand what this assessment is saying. You're going to get background information about your client. You're going to get the position of the hospital, prior dispositions, if there are prior dispositions, all that's going to be contained in the materials you're going to get. And with all that information, you're going to want to have another meeting with your client, sit down with them, discuss the information contained, think about strategy. So you're going to want to discuss whether or not they want to provide testimony. More often than not, they don't. Sometimes clients do want to provide testimony. When they do, very important that you give them warning about the fact that they could be cross-examined, and perhaps some of the questions that they're going to be asked are things that might not put their case in the best light. And then it's very important to, get final instructions based on all of that information, in terms of, what are we looking for? Are we going to be conceding the significant threat? Never. And, what's realistic to look for? Can we get, certain privileges? Can we get you in the community? So we're thinking about strategy and, finalize that. And then, I'd like to have a conversation, if I can, with the clinical team I also try to have conversations with family members and other people that are connected to my client based on their permission, getting their consent. I do find it very helpful to get that collateral information. It gives me a better sense of who my client is. It does also help establish rapport. And then you might want to be thinking about the kind of evidence that you want to be tendering at the hearing. Maybe it's support letters from family members, friends. And again, you want to be thinking about the relevant legislation. So there's the twin goals that Michael was just talking about. And a component of that is thinking about your client's mental condition, their integration needs, as well as their other needs. And I think of those needs as like their social needs, the vocational needs, educational needs, and so on. And, got to kind of finalize a strategy and try to maximize what you can at the hearing in terms of getting the best outcome in the disposition for your client. So, yeah.
You know what's been fun? Getting them the right to smoke cannabis. As soon as cannabis became legal, perhaps unsurprisingly, all our clients wanted to smoke some. And it's like a subspecialty I have now. A reputation in one of the hospitals, I got one guy a cannabis exemption from prohibition, and 20 other people retained me like in the coming months. Is the girl that gets him the pot, but it's actually a really fun area. Now, thank you for that, AJ. I think I'm gonna ask the next set of questions, and I know there are other things we want to talk about as well, such as addressing anti-Black racism at the board and in forensic psychiatry. For years, we were told there's no anti-Black racism in forensic psychiatry, and certainly not at CAMH. Recently, CAMH came out with a big report on anti-Black racism in forensic psychiatry and at CAMH and what they're going to do about it. So that's good, 20 years after the fact. But we'll have to edit that out of the video, I guess. Next question. We got this question in as part of the application. So I think we'll let Leslie answer it first because she's the board. The question that came in is, what is the reason for accused persons serving decades under the Ontario Review Board when they would never even have gone to jail for the offenses that brought them into the system? In Quebec, NCR persons spend very little time under their review board. Why does Ontario make these things into life sentences? Or if not quite that, keep people in the system unnecessarily long to the point that people refuse to seek NCR even when it would be available to them? And sort of a subpart related to that are, what are the impediments to getting out of the system? What are the impediments to discharge? So I'm hoping everyone has some comments. We'll start with Leslie, maybe just make our way down the.
First off, it's just no part of the scheme or our role to be punitive or to supervise the accused in some fashion that's commensurate to the offense. Like, that's just not written into the system. It's all about predicted risk. Are they a significant threat to the safety of the public? The index offense is one factor that goes into that calculus, but there may be strong evidence of risk aside from the index offense, either from their time in the community before the index offense or their time in the hospital. It's pretty clear that some of the cases that end up under the jurisdiction of the board involve individuals who have been in a community for a long time. They've been subject to mental health diversion. The police in the community know them. The mental health services know them. The Crowns know them. And at some point, everybody decides, we're throwing up our hands. It's NCR time. And that's when you get somebody with a minor offense who then comes before the board and has this long history that speaks to risk. You heard the last panel talk about why you want to be so cautious about going down that road. Having said that, there are services available in the forensic system that are pretty hard to access in the civil system. Two other factors I want to just hit on very quickly. One is, forensic psychiatrists are in the business of looking for risk and what's driving risk. Over time, I think some become quite cautious. I think that happens to board members too. It's a bit of an occupational hazard. As advocates, I think it's a bit of a puzzle for you to solve, to try and undermine that inclination to be overly cautious in assessing risk. That's the job. Quebec culture is just different, honestly. You know, they sentence offenders lighter, that it is just a different culture.
They're still smoking.
Finally, resources are a big issue. You know, resources to progress patients through the system at every stage, the programming in hospital, the assessments that will help everyone figure out what's needed to progress this patient, and probably first and foremost, supportive housing that allows the transition to living back in the community.
I think your first point is really important because, you know, the public loses their mind when someone who had a homicide index offense comes out the other end of the system in just a couple of years. But there's not a lot of public outrage about these people with mischief and utter threat and theft under who come into the system and 10 years later are still in secure custody. And I frankly feel equal outrage more about the second set myself. So following up on my outrage, do you have any outrage?
I don't have any outrage, but I can speak to some frustrations about working.
Frustration, if
With
that's the
some of
best
these
you can
cases.
do, Mark, that's, if that's. the
Yeah.
best you can do.
It's a nicer.
Go ahead.
Maybe nicer, better word for
Gentler.
choose is frustration. So, you know, as a forensic psychiatrist, I'll get emails saying, can you do an NCR assessment on this person with this theft under charge? And I always think like, oh, geez, do you really want me to do that? You know, is that a good idea? I mean, and well, ultimately we do what we're retained to do. We do what we're asked to do, but and I purposely, you know, don't think about whether or not it's good for the patient or not, because then I might be compromising my opinion to the court, right? Which is not my role at all. And I can't get invested at all, you know, either way about what the outcome may be and whether that's quote unquote good for the patient or paternalistic from a paternalistic point of view. But I mean, I think a lot of these patients end up in the system for a long period of time. I mean, we know what diagnoses are associated with that, and they tend to be personality problems and substance use disorders. And with those diagnoses, you do have trouble conforming to the very rigid routine of the hospital. And I think Anita told me many years ago that if she ever got admitted in one of these units, she would never be able to get out,
Never
right?
get out.
Because
Secluded.
she won't
rest
come
of
back
my
from her
life.
smoke breaks on time.
Never get
You
out.
know, she might, you know, be a
Never
bit grumpy
get
in the
out.
morning. You have to think about what it's like in the hospital, and that, you know, you want to go out 6 times a day for 30 minutes at each time to go have a cigarette or go for a walk or fresh air. And each time you may have a nurse who's going to ask you the same set of questions over and over again, including, are you going to go kill yourself
Yeah,
today? Are you going
number
to go
one.
harm someone today? So think about having to answer those questions, you know,
Every
6
day.
times a day just to go out, right? And so you can see how
Going
this
for a smoke. You're going out
can lead
kill
to people who have, you know, poor coping skills or short frustration tolerance, or just a, you know, maybe what we might call an attitude, to them not doing well, right? And so it can end up in, you know, they might do well then for a few months, then they're having a bad day, and then they have an outburst on the staff, and then all of a sudden, oh, you know, this is risk enhancing to public safety. We then have to curtail their liberties, and then it's a vicious negative cycle, right? And so, and I don't want to blame anyone or any part of the system for that, but there is like the way we train nursing staff is to be quite, you know, they have to give medication at a certain time. A patient has to be back at a certain time, right? And as soon as they're not back at, you know, exactly 10:30, or they come back at 10:33, it's seen as this big
They're
deal.
AWOL.
They're AWOL. It's a big deal, right? And I mean, once in a while, it is a big deal, but that's 1 out of every, you know, 100 or 1,000 times, right? So, and ultimately, it is the person in charge of the hospital that does have to approve all these privileges based upon recommendations from that same clinical team. And so, you know, one of the least favorite parts of my job is privilege review day, wherein I have to negotiate with the staff about why this person can go out for an hour or 2 hours, when, you know, I just as soon as I mean, my view is to be more liberty-minded, right? And so maybe that's why Anita likes me, you know, so
Maybe.
I have to be cautious of that, though, in terms of
You think
balancing.
maybe? Yeah.
I have to be still fair to both sides, but, you know, negotiating that, and we have to keep in mind that we can only stop people from doing things if they're dangerous, right? And sometimes the hospital staff, including other colleagues of mine, lose sight of that, right? And so the question asked is, you know, are they going to harm someone if we allow them to go to the community for 3 hours, or if we allow them to do this, or what's the risk of that, right? And And so I always try to, because that's what the legislative framework tells me I have to think
Yeah.
about it. So I always try to think of that, and that helps, I think, navigate some of these issues for these patients. But certainly we do have a subset who do remain in hospital despite our efforts for years.
I do like the liberal-minded psychiatrists. I remember, I think it was Dr. Palandi, when I was a new lawyer, so this was many years ago. One of my clients, his patients kept going AWOL. So Derek said, why don't we just discharge them? Absolutely. They seem to want to go, like they just keep going. I thought that was a very good response to repeated AWOLs. I think we should just, we're not doing anything.
Yeah, I
So-
mean, I don't have so liberal minded, or just that I do keep remembering that the framework is that it's about public safety and public safety risk. And I always try to remind myself of that. And that's the only reason why we can hold their passes or, you know, curtail their liberties. And if I can't make that logical jump to the fact that they are going to harm someone and it has to be serious harm, right? Then I feel that we should be curtailing their liberties. So I guess my liberal mindset comes from my interpretation of why we're keeping them and how we're keeping them in hospital.
You're just complying with the law. Admirable. AJ, why can't our clients ever get out?
Well, I mean, for me personally, my view is that non-serious index offenses, persons going into the forensic system should have a cap in terms of how long they end up in the forensic system. I don't think it makes sense from a fiscal standpoint in terms of what the public's getting out of it. I think the cost for a forensic bed at CAMH is about $400,000 a year. I question if that's a good investment. Perhaps we can invest some of that money more on upstream kind of prevention, more community-based mental health support so people don't end up in the forensic system in the first place. So rather than putting all the money on the back end, maybe more of an emphasis on community-based supports for people so they don't end up in the forensic system. So, but then, you know, like I do understand that quite often people that end up in the forensic system are people that maybe for lack of a better word, they failed out of the civil mental health system. You know, this is the last stop for them. There's not a lot of other supports for them and they end up in the system. And so it is a resourcing issue. It is a housing issue. There's not enough supportive housing or transitional housing or housing specifically for the forensic population. And so that does delay people from getting releases and from transitioning from the forensic system when those resources are not available in the community. And it is quite concerning to see people with what I would regard as non-serious index offenses end up with a ad infinitum, you know, going on forever type of custodial forensic, you know, hold.
Oh, there's extra time now for you, Michael. AJ's answer was little.
Little short.
You have 8 minutes. Don't feel you have to use them all.
Okay.
Well, I'm
Oh.
sure I've often thought about how I would fare in a hospital report if I were detained in a hospital, and as many panel members could probably guess or surmise, I don't do well with authority figures. So it can be extremely difficult to be in a hospital, especially as I think Mark's line set out the routine. You know, every institution has its own routines, and I'm always interested in how that could be made more flexible and more sort of individual friendly. But Leslie's right. It is. I'll sort of make a couple points about the CAPI. First of all, Jamie Cameron, who's here today, Professor Cameron, has written a very excellent piece on the issue of the long-term detention of forensic patients, and specifically talks to CAPI. And I really encourage you all to read it. It's very.
Where's that piece?
And that would be in the famous anthology. I think it was recently published in Canada.
Such a good piece.
Yeah. But I do commend you to take a look at that. You know, it's I think that question cited the Quebec example and having come from being raised in that province. I mean, I sort of get their system. And I think you have to sort of see this issue on a spectrum. It's not a black and white issue. If you veer too far to one end of the spectrum, you're going to get a public reaction, perhaps even a legislative reaction that we saw with the Reform Act of 2014. And in Quebec, as you're now, some of you may be aware, there is now a reaction to the level of release rate in Quebec. The recidivism rate was a piece in the devoir that got a lot of fanfare back in, I think, last fall. Pointed out was about a 25% rate of recidivism, which is getting up there. And it's a very different system, but you can sort of see this is the tension of the system. I don't care what anyone says about they want to put some kind of formal structure upon it, superimpose it like capping. It's not going to change the fact that if you're releasing people and you're going to get a high level of reoffense, the public's patience with that is going to be not going to be very generous. On the other hand, and I think Anita makes a good point, you don't hear outrage about the other end of the spectrum. That is where people are kept in a long time. That's usually the professionals who articulate that. But to tie it to the index offense, with all due respect, that's sort of getting into the thinking that led to the HR, the high risk accused as well, was, well, it's a very serious offense, therefore it must mean this person is much more risky and we must have much stronger controls of them. So you're going to always get it at both ends of the spectrum. I'm not saying they aren't legitimate or valuable discussions and we should be constantly on top of examining this issue. But just to say, oh, well, it's too long in Ontario. Well, if it gets too short in Ontario, you're gonna hear about someone's gonna raise a fuss, and then you're gonna hear about legislative. We've got to find another way to do it. Okay, I'll shout right
Oh, that's it?
there. Well, there was a little sign that.
There's a little something. I think,
But yeah, I can tell you this though, that
okay,
like
this is how the hearings go. Yeah.
well. Well played. The rate of recidiv, what was it, what I want to say, in Quebec, yeah, just the interest, and sorry, under chalk, I think under the LG's warrant, I think in chalk, they say it was 6 years was the average. So when people talk about decades or 8 to 10 years, I think that's a misrepresentation of the average period. But just to give you some idea what that Montreal study did a little bit of a comparator of the provinces. So after 1 year of review board, Quebec releases 74% on, Quebec retains 74%, Ontario retains 92%, BC 82%. After 5 years, Quebec retains 19%, Ontario 58%, and BC 31%.
Yeah.
So you can see the play in the different jurisdictions.
I think the problem is at 10 years because there'll be nobody left in Quebec, but we still have a substantial number here.
Yeah,
That's
I
what-
think why they don't go that, there's a reason, it's the sort of stats reason why they don't try to do a prediction over 10 years. But
So even though we don't have time to talk about this, the answer to why nobody ever gets out is there's no housing. And I think we can all agree that that's a problem.
Yeah.
We have 2 minutes left. Is any final comments? Anybody on the panel? Except Michael?
Michael, I'd give you lots of passes if you were my patient.
Okay.
One final comment. I just wanted to talk about an important issue, which is anti-Black racism in the forensic system, in the criminal mental health system. I've done some research in this area, and what I found quite alarming is that there's been a study that indicated that although Ontario's Black population, adult Black population is about 5-6%, the forensic population has about 23-24% Black people.
Yeah.
It's very significant, and it's even more alarming when you compare that to even the custodial or the jail population or the prison population in Ontario. So the prison population, taking consideration over representation of Black people in the criminal justice system over policing, is at 14%. So it's even much larger than in the prison or correctional context. And that begs the question, why are we seeing such alarming demographics in the forensic system? My personal opinion and what I've seen in studies, it's a reflection of, yes, over policing, issues in the criminal justice system in terms of systemic racism, institutional racism. But we also need to think about how do we address these issues in the healthcare context, in the mental health care context. What are the issues when it comes to people getting access from these communities, equitable access to healthcare in a timely manner, why are so many young Black men, getting into the forensic system or getting into the mental health system through aversive pathways. So more so through police contact or through the ambulance rather than just, going to the hospital. So these are important questions that we need to address if we want to bring down that number.
And once in hospital, why are Black accused persons secluded more, chemically restrained more, physically restrained more, secluded for longer? Why?
Very, very uncomfortable conversations to be had. I can tell you from my experience, litigating it is not easy.
No.
I think the board typically wants to see actual instances of racist acts or non-acts. It's difficult to present evidence at an ORB hearing of systemic racism. I do encourage, counsel for the accused, perhaps to raise this as an issue, in a pre-hearing conference. Encourage the board to look at, getting expertise on this kind of issue. Perhaps even look into getting like an impact of racism and cultural assessment report, or impact of race and cultural assessment report that's used in the criminal justice context. So those kind of reports are pre-sentence reports that can talk about, what's going on with this individual person, how they have been impacted by anti-Black racism. It gives them, the board, some context to understand what brought them there. It can personalize them beyond, just the information that's in the hospital report, and maybe help the board make more better informed decisions, in terms of their disposition.
And I think we're well out of time, but I commend to you in the lovely big fat book, AJ's chapter on this, on anti-Black racism and litigating such issues at the review board, which is a very important chapter. So thank you so much, everyone, for
Thank you.
thanks.